Good morning, everyone. It's a great pleasure to have you all here, and it's a great honor to have Professor Joshua Wright with us today. He will speak about the recent developments in the U.S. antitrust policy, and this is a theme that is very interesting for us, especially due to the last changes in the antitrust administration or the administrative board in the United States. So we are reading lots of things about the possible changes in the antitrust policy in the United States and also in Europe. So this huge discussion about antitrust laws being sufficient or enough strong to fight the power market of the big techs. So what will happen then? And so we're going to have changes in the law. We're going to have changes only in the policy. The administrative boards will get more power to fight monopolies and big techs, or a new bill will have to pass in the Congress to authorize this, and how the courts will see this change in the antitrust policy. So there are lots of things that the professor has agreed to talk with us. So I thank him again, and let's go to the panel. Thank you very much, all.
Just to say some initial remarks here, to thank you, Professor. It's a pleasure to have you here. This is part of a broader initiative from Ibrac to hear from great scholars around the world, to give their views on what has been going on around the globe and that can affect us. From my early learnings in competition, we always see the pendulum in the United States, how it goes and comes according to democratic or Republican governments. And I think this is the most, I believe, for me at least, is the most clear shift of a pendulum that I've ever seen in U.S. history. So I would very much be interested to hear whether this is a small or a big wave, and how does this how will this be affected by also the state enforcement that we saw recently to get more eager on big techs as well. So some of initial thoughts here, and again, Professor, it's a pleasure. It's a great pleasure to have you here. Hope we can debate for other times as well. Thanks a lot. And Sylvia.
So I would reinforce my thanks to Professor Joshua, and I would like to thank you all of you for joining us today here. I think it will be a very interesting panel, because as Laura mentioned before, in respect to digital markets, antitrust decisions and interventions are getting polemic, very polemic, and also there is no consensus about what are the better tools to enhance competition analysis. And in this context, the U.S. jurisdiction is, of course, one of the important references, not only for Brazil, but for other jurisdictions. So understanding what's happening there is very important. And this is why it's very good to have the chance, the privilege to discuss it with you, Professor, and the Brazilian community here. And it seems that you have very good news, or not so good news necessarily, but interesting news from last night. And there was very important bills being voted that may represent the most significant changes in the U.S. antitrust laws in decades, right? And bills that can make it easier for the competition authorities to break up big techs, to block big tech companies from buying their competitors, and bills that can make it easier for consumers to make their personal data available to competitors. And of course, it includes interoperability rules. So we also intend to discuss, of course, this important shift that is happening right now. And we also intend to discuss other important topics, in our opinion, that includes the nomination for key antitrust position in the US, the reaction of the market, especially how big techs are reacting in the face of this shift in antitrust policy, among other issues that even the audience can bring to us to discuss. So without any further delays, please, the floor is yours, Professor.
Thank you, Sylvia, and thank you all for having me. And it's pretty good timing in light of last night, so I'm happy to be here in a timely fashion. It's a lot to talk about, and so I thought one of the things that I would start with is, for context, how I see the pendulum swinging narrative in the U.S., at least until very recently. I do think that the environment in the United States right now, in terms of the political economy around antitrust, is certainly different than I've ever seen it. And so I wanted to point out some differences, but maybe highlighting the context of the history of the last 20 or 30 years will give you a sense of what's different, new and what's not. I say that because I think one of my punchlines to you is going to be, there are a lot of things in Congress that are not going to become law. There are a few that will. And I think the history will help separate out the real prospects for legislative change versus ones that I think will get a lot of attention. We'll have hearings, we'll have proposed bills, but will die before they become law. So let me start a little bit with at least what my view of that, what are normal political swings in the US, and what I think is different about this one. I think the conventional wisdom for political swings administration to administration, and I've been inside the Federal Trade Commission during administrative change. I became a commissioner right during administrative change. But I think the normal conventional wisdom is horizontal enforcement, or our Section 1 enforcement does not change at all. If anything, typically in Republican administrations, criminal enforcement goes up. There's a little bit more shifting resources towards Section 1 and horizontal restraint enforcement and away from unilateral conduct. Not, binary, not all or nothing, but a shift on the margin in that direction, where merger policy stays relatively constant, at least if we measure from activity level. I mean, if you were to look at our second phase, our second request rate over time, the data are incredibly stable for the past 30 years, 2%, 3%. The second request data are incredibly stable. The number of preliminary injunction merger challenges that go to court, incredibly stable over time. Now you do get some shifts in which mergers are being challenged, what industry in administration cares about. Maybe the line moves from mergers that are 3 to 2 from 4 to 3 or something, but marginal shift in focus and enforcement focus, but activity level on the merger side, the data just don't show that, nor do I think does certainly my experience in the agencies. But what you do have is a little bit of a shift between horizontal restraint enforcement, criminal enforcement on the one hand, and monopolization on the other. To give a sense of this historically, when President Obama was elected and Christine Varney became the head of the DOJ's antitrust division, one of the first things she did with much fanfare in the United States, so she held a big conference and she held up the recently signed Section 2 report. I need a better prop, but I'll just wave my hand, but pretend I have a big report. She waved it around and I think threw it in the trash or something dramatic, and said, well, we're throwing this out and we are going to reinvigorate Section 2 enforcement. And they held mini conferences and they brought one case. The Bush administration before them brought one case. They both went 0 for 1. So I think it is really, so what we're talking about on the margin usually is, a more active administration brings 2 or 3 unilateral conduct cases. Maybe a less active one brings 1 or 2. So small changes, much more in the policy focus than in changes in enforcement. That's sort of the bullet point version of what I think of as normal pendulum swings in the US. Maybe a little more willingness to litigate. Republican administrations much more like to spend litigation time and energy on state action, attacking government restraints of trade. So I think this is not the same. And so I want to highlight what I think some of the differences are in the political economy. And let me start with 2, and then I'll kind of get into what's going on in the courts and Congress and the agencies, probably in that order, to highlight some things. I'll certainly tell you, I'm not very shy. I'll tell you what I think about all of them, and we can talk about more of it in conversation. So 2 things that I think are especially different about the current political economy. The first difference is in those debates over the past 30 years or so, they've occurred almost without any involvement at all from our legislative branch. They've been conversations between the agencies, the DOJ and the FTC. They've been conversations between our agencies and the rest of the world's agencies. They've been conversations between our agencies and the academic community. But they almost never have been conversations between our agencies and oversight from Congress. We have oversight hearings. We fight over the budget. But in terms of major legislation aimed at either expanding or contracting the powers of the agencies, as opposed to playing around with their appropriations and their budget or with nominations and personnel, very few and far between. Proposed bills from time to time that are discussed, but nobody really thinks are going anywhere. Yes, plenty of those. We have no shortage of legislators who would like to sort of do bills for signaling purposes, but nobody thinks they're going anywhere. We have plenty of that. But in terms of real legislative attempts to change the landscape of antitrust institutions and enforcement, largely absent for the last 30 years. No comment for now on whether that's a good or bad thing. I think your mileage may vary and people's opinions differ on the sort of optimal level of legislative, congressional control over agencies. I can certainly tell you when I was in the Federal Trade Commission as a commissioner, I did not welcome calls from Congress. It was usually bad news when I got them. But from a societal perspective, most of what has happened in the US has been budget authority, discipline over the agencies over budget authority. Okay? This, I think, is different for a couple of reasons. One, you've seen the scope of the bills, and I'll come and talk about some of the specific bills in a moment. But it is no doubt these are not minor tweaks to the system. Most of these are major overhauls, some of them sort of openly with the goal of transforming the U.S. the U.S. antitrust institutions. Okay. So big ticket items across the board. A second difference in the political economy, obviously, is the political economy around big tech and platforms. The U.S. political dynamic on this front is odd. We've had for 30, 40 years attempts to do bills like these. Some of them fairly radical from an antitrust perspective in the types of things that really haven't gotten off the ground. in the United States. And in terms of not to or maybe to oversimplify, in left and right politics in the United States, the left has advanced bills like this for a very long time. There have been different bills that look like the bills that have come up since the 1960s in the United States. The vertical separation bills, the merger presumptions, the switch from effects to, this is stuff that's happened in the US since the 1960s with differing levels of popularity. Some of them have new names, and you put, platforms in the names and you sprinkle some glitter on them and they look new and shiny. But the ideas are the same as things that have been around for a long time. What prevented them in terms of the political economy from ever passing or being serious threats of passing is the standard view from conservatives in the US was skeptical of those types of pieces of legislation, either because they were too interventionist or they gave the regulators too much power, etc. Another thing that happened in the political economy in the US that I think is important and is judicial review is a large part of our system. I would say when I go around the world to do antitrust lectures, I tell people the consumer welfare standard is I am a fan. It's great, but it's not the signature sort of item of U.S. antitrust law. By my lights, it's some version of it is in a lot of places. The sort of signature distinctive features of the U.S. antitrust system, in my view, again, whether good or bad, are the role of judicial review in our system. And also, I think the place where we make the dividing line between the protection in our case law around a monopolist who earns its market position by competing about being able to charge the monopoly price. These are 9-0 Supreme Court decisions, not touchable by any form of litigation or antitrust challenge. Lots of things a monopolist cannot do, but the protection surrounding price and product design decisions for a firm who earned its spot through legitimate competition, I think are strong in U.S. law, and maybe strong in a distinctive way. If you read Justice Scalia's opinion in Trinco, there is what amounts to a love poem to the monopolist's ability to charge the monopoly price because it attracts entry and innovation and all of those things. It's sort of much stronger form of that sentiment, shows up in all sorts of other countries' antitrust laws. I think the commitment to it in U.S. law is distinctively strong. The conservatives in the U.S., because of the role of judicial review in antitrust, have historically been against strongly anything that shifts from the courts to the agencies. And so the big influx of judges in our federal courts happened during the Reagan administration in the 1980s. And so a lot of the Scalias and Thomases and my colleague Judge Ginsburg, who in the DC circuit who wrote the Microsoft opinion, Easterbrook, Posner, these are all 1980s Reagan appointees. And so the conservatives in the political economy in the US have grown up around the idea judges good, regulators bad. This is oversimplifying a great deal. But for the context, so to understand what is changing or different now, I think that's an important point. The political right on the U.S. has been skeptical of moves away from courts and toward empowering regulators, not just because they love markets and small government, sort of the normal sort of right of center political line. It's that too. To be sure, it is that too. It is skepticism about regulation. It is the American experience with regulation. We had an antitrust system that looks like what these bills want to do. We had that. Most of the 40s, 50s, and 60s, we had that. We had a regulatory system that looks like this. We had structural separation. We had big common carrier regulation across a lot of industries. Most of the evidence is it did more harm than good. There are exceptions, et cetera. But again, to paint with a broad brush, the experience with that regulatory and antitrust system in the United States was one that is not a happy one for competition or consumers. And I think all of this sort of informs the US skepticism of that sort of approach. But I think what has changed is the conservative skepticism, especially drawn out by the politics around 3 or 4 large tech companies, sort of changed the game a little bit, right? When you hear in these hearings, and I watched as much of them as I could before I had to fall asleep, but when you hear the hearings, the Republicans that are attracted to these bills are largely not attracted to them for reasons that have much, if anything, to do with antitrust. Again, few exceptions. Most of them are interested in bills that address the perception that these firms discriminate against political viewpoints of conservatives in some way, shape, or form. Whether it is in search results, whether it is in kicking apps off an app store, whether it is the political motives of their CEOs. There's sort of a widespread view that that is the thing to attack. And I think one of the surprising things by my lights, I'll sort of jump ahead to the House a little bit. I think one of the surprising things by my lights, there's sort of 2 things that are surprising. One, a bunch of Republicans voting for highly interventionist regulatory bills. That is surprising and new in the American experience on antitrust, I think, and is the headline of most of the news stories, right? I think that's the sort of instinctive, sort of intuitive surprise. I'll say the other side of that coin is, I mean, some of those bills failed because Republicans wouldn't join them. Some of those bills, despite the fact that they were attacking large tech firms, I think a lot of those bills sort of hobbled through the House, passed on largely partisan grounds, with Republicans holding the line against them as if it were the 1990s or 2000s, right? Sort of the old political world I was describing held on a lot of those bills and not on some others. We'll get back to that in a second, but I think that's an observation that at least the morning papers here sort of skip over a little bit because bills about big tech is a sexy headline. So no doubt, however, that the political economy, you get this sort of attraction to at least some of the Republicans, and they're pretty clear from these House hearings now that there's some factions developing, but the sort of biggest voices in the anti-tech Republican crowd joining together with the Dems to pass some of these bills largely targeted at tech firms. That joining of kind of one end of the right with the left, I think is new in our politics and important in a variety of ways. And the fight that is happening on the right is happening in real time, and I don't think is over by any stretch of the imagination. The themes and arguments going back and forth. You take Jim Jordan, who is the chair of our House Committee on the Judiciary for where all these antitrust bills come. Jim Jordan is an adamant supporter of the consumer welfare standard. Jim Jordan voted no basically on all of the bills, except maybe 1 or 2. And Jim Jordan's view is, and he sort of challenged his colleagues throughout the hearing along these lines, is you can send these cases to the Trump judges or the Biden regulators. And he won a lot of support with sort of rhetoric like that and has attracted a large crowd. That fight is ongoing, and I don't. My view on who wins it and $5 gets you a cup of coffee, but that's ongoing, and I think it's important to understand that it's ongoing. I'll talk a little bit about agency appointments and their role in that fight in a moment. But those 2 things, I think, the intensity of the involvement from Congress and the new politics on the right, I think, the right needs its pound of flesh from big tech, and the fight is over, does that form of the pound of flesh come through antitrust or some other mechanism. And most of the Republicans on the political right would tell you they don't care. It doesn't matter if it's antitrust or Section 230 and protections over liability for content on platforms and content moderation decisions, or if it is just, public lashings. I don't think that most of the Republican supporters of these bills are particularly interested because of their antitrust implications. And so the bills that have tended to get support from those Republicans are not, I don't know if this term works, but they're not true antitrust bills in that they change the antitrust laws. They're bills that are carved out to apply to 4 companies. They're defined around 4 companies, right? And, they're actively trying to avoid large spread changes that apply economy-wide because they'll lose support from the rest of the Republican caucus. And they'll start hearing from firms in their jurisdictions. It's okay to take a pound of flesh from Google, but it may not be okay to take a pound of flesh from a manufacturing firm. And a lot of these bills have a hard time narrowly tailoring their impact. So that's sort of the way I see the political state of play. I'll take a little sort of tour through the courts and Congress and in the agencies to give a sense of what I think is going on there, and you can ask me whatever you want about it. But in the courts, you guys probably know the suits that are going on as well as I do, but you've got a number of lawsuits, a couple from the agencies brought at the end of the Trump administration. So you've got the Facebook suit in federal court that has the sort of retrospective merger claim. It's got the WhatsApp, Instagram sort of merger divestiture claim for the consummated deal. And you've got sort of an API related, what I would describe as a refusal to deal claim that went through 3-2. And you've got all of the states joining some version of that complaint in some form or another. So it's sort of one bucket of suits. You've got the FTC's Facebook suits already out the door. I think already argued motions to dismiss. Probably will go through full motion practice, summary judgment motions and the like before hearing. I'm happy to talk about the merits of the suits all you want, but let me sort of run through what's in the world. You've got the Google suits. So to start with the DOJ suit, which is the sort of phone search syndication suit about default search engines. So a little bit more narrow than the state suit. So you've got the DOJ suit about payments to be default either on iPhones or Android phones, and the state suits led by Colorado and Texas, sort of broadening the set of claims to include, as opposed to search distribution, what I would describe as a search design case in Colorado. That is the algorithm, the search results itself impact competition in a negative way. This is akin to the FTC's investigation in 2013-14. It is the search itself, disfavoring vertical search engines, that sort of thing. And then you've got the ad tech parts of that case, which are both in the Colorado complaint and the Texas complaint. And you've got sort of various self-preferencing and other claims addressing the ad tech stack. So you've got a lot of suits in a lot of places. Right now, interestingly, the federal suit, the DOJ suit, scheduled for trial in 2023. I think towards the end of the year in 2023. I think one of the poignant and one of the criticisms of the U.S. system, and one that lands, I think, and is effective, and there's a lot of truth to it, is at least when it comes to monopolization cases, we're really slow. Painfully slow at times. I mean, there's a trial set 1.5 years from now, or 2 years from now, and we'll get to that a little bit in the bills too. but the Google suits are there. You've also got the aftermarket app store suits. You got sort of Epic Apple rules of engagement for kicking out of app stores. There's Epic's got the suit against Apple. It's got another kind of copycat suit against Google for its app store that is there. In terms of the big tech litigation, that's all what is sort of out there in the landscape. Undoubtedly, you will see more. There are some other things going on, I think, in our antitrust landscape in the courts that are relatively important. One, I guess this isn't in the courts yet, but one of the things that the Biden administration did before nominating and confirming Lena was end early termination in the U.S. for merger review. If I lined up 100 U.S. antitrust practitioners who do merger law in front of you, and we took a poll right now, and they said, what's more important, any of the stuff I said till now or ending early merger termination, they would say the latter. So the agency does a second request on 2% of the deals. The rest of them get through the system, and many of them get early termination, and the parties are allowed to close before the end of our HSR waiting period. And the then acting chairwoman, Becca Slaughter, because this did not require a commission vote, simply announced we aren't going to do that anymore. So just ended early termination sua sponte. By pandemic response or something like that. I'm not sure if the announcement gave a lot of reasons, but the political context was one of the bills floating around on out of the House from the Democrats was a flat out merger moratorium, was a ban. And so there are many who look on the sort of procedural tweaks and institutional tweaks to make merger closing harder as if you can't get the ban through politically, you might as well raise the cost of all mergers. Politically, I think it would be impossible for an FTC chair or even a congressman to say those things out loud and get them passed. And so they don't say them out loud. They just sort of ended the program in the middle of the night, and have it still to this day. Early termination has ended, has not come back. So there's been a little bit of more dysfunction than normal in merger review. I'll give another example. This one did end up in public statements, but the 7-Eleven Speedway deal in front of the U.S. Federal Trade Commission ended sort of ugly. I have a different view of these mergers that end in public statements because having seen the animal, the way the sausage is made inside the agency, sometimes the documents speak to you a little differently. It is pretty clear from the public statements, and 7-Eleven issued a statement on their own. They entered into 4 or 5, I forget the number, 4 or 5 timing agreements with the agency. They were going to divest some stores and get the merger through. They entered into 5 timing agreements with the agency, which is not uncommon. You go and you negotiate your settlement and work with the agency to figure out which stores you're going to divest and agree with them. We won't close as long as we keep on bargaining in good faith. And so, parties put off closing their merger for 3 months, 4 months, 5 months to work with staff. They ended up with a deal. The staff sent the deal to the commission, recommending to accept the consent package. The commission sat on the deal, on the package for 3 weeks. And then 3 days before the closing date said, meh. At least one of the commissioners said, well, I'm going to vote no. And it's a 2-2 agency situation at the time. So this results in a lot of dysfunction, and it undercuts the staff a great deal. The staff are very unhappy when this sorts of things happen, because when they go to parties negotiating a deal and say, let's enter a timing agreement, because if you and I enter a deal, the commission is going to approve it most of the time. The credibility of the staff gets undermined a great deal. And I think that's going to be one of the challenges, and skipping a little bit ahead to Lena and the FTC, in the FTC. Adventuresome changes are not just political. I mean, moving things inside the agency is very difficult. Telling the agency staff to litigate when they don't want to litigate, or litigate a theory they don't want to litigate. Or if you've got a much more adventurous, aggressive view of the antitrust laws, litigate cases where your probability of success in court is lower. The staff internalizes a lot of those costs, for better or worse. They don't want to lose the cases. They want to win the cases because they're good lawyers. They want to win the cases because it gets the attention of the outside bar, and they leave the FTC to go to a firm and make money and live happily ever after, or whatever. They say no, they fight on the complaint. Now, the chair has control, but it is very difficult, I think, in an agency over a long period of time to win those battles with staff every day without a lot of experience with how the agency works, relationships with agency leadership. People skills still matter a great deal. Experience in the agency matters a great deal. And I have a lot of respect for Lena, and I know her really well. But some of those things with staff, I think, are challenges that there are not many people in the world that are prepared for. I certainly am not claiming that I am either, but I think it'd be very difficult to effectuate that sort of institutional change inside the agency without having been there, and been there for a long time. I think that's a difficult thing. Change outside the building is different. You convince Congress, that sort of thing. I think she'll be wonderful at. Inside the building is different, and I think will be a challenge, because these sorts of changes that have been implemented by the Democratic leadership of the FTC so far are the types of things that get staff against you, not for you. I happen to also think those are bad policies, but that's sort of irrelevant whether they're good or bad policies. I think they're the type of policies that get staff lined up against you and create more inertia, not less. And I think that's going to be much more than some of the challenges that are being discussed. I think that's going to be a very, if not the primary challenge, for Lena as she runs the agency. And it's going to be, it's got 2,500 of the best lawyers and economists and administrative staff in the world are sitting in that building. And if you're at the FTC, you really want them working for you, not against you. And that's that can be tricky. Let me talk about Congress, then I'll just let you ask me whatever you want, because I realize I've gone about 40 minutes. So the bills, I guess, are the hottest topic at the moment. So let me sort of run directly into those if I can. So you've got the House and the Senate. So we talked some about the House already. I largely view the bills as coming in three buckets, three categories, if you will. They're the procedural institutional bills. So think merger filing fees, bills that expand transactions that are noticed under the HSR Act, mostly addressed at like killer acquisition type concerns, so you're not seeing small deals or whatever. Merger filing fees, tweaks around our administrative litigation process. I would view there's this state AG venue bill to adjust the ability of parties to transfer venues and multi-district litigation. This arose largely because of Google's attempt to move its multi-district litigation. So lots of states, they file in lots of places, and they put them all in one multi-district panel. And when you put suits from lots of different courts in one multi-district panel in federal court, our rules will let the defendant remove the case to a venue that's convenient in large part. And so Google tried to bring the suit home to California. There are some attempts by the state to prevent that. They would like to sue them in districts that are more plaintiff friendly in antitrust cases, right? So nothing new. People fight over venue to affect the probability of success. Fine. The legislation restricts the ability for defendants to move venue in those types of cases. I think that I view as largely a sort of institutional procedural bill. Appropriations are in there, sort of budget for the agency, reports they have to do, kind of all of that procedural and institutional bucket. In that bucket, I think there are some pieces of legislation that will become law in one form or another. The budget bill will pass. The agencies are going to have more money when this is done. They're going to have some restrictions on what they can do with it, but they're going to have more money when this is done. The venue bill is probably going to pass. Even the people who don't like the venue bill, I don't particularly like the venue bill. I don't hate it. It's fine. And it's hard to get excited about. I am not excited about it, and it will probably pass. Some of those from that procedural bucket will pass. Some might not. They'll fight over how much budget, and I think the venue bill will go, but not much else there. Okay, but some of those will certainly pass. In the second bucket, I would describe as the sort of big tool regulatory transformational change. We've got like a copycat bill of the DMA, the structural separation where, Amazon can't sell you Amazon basic socks and t-shirts, and, your iPhone can't come with apps on it, and all of that. I will bet all of you, each of you, a delicious beverage of your choice that none of those pass. You can come collect. You have to come here, but you can come collect from me anytime. If I'm wrong, open invitation. None of those are going to pass. Some of them hobbled through the House with lots of no votes. Our Senate is split equally, and they're just there's just no way they survive the Senate. You have Dems who vote against them. They're Democratic senators in states where there are companies, and most of the companies don't like these bills. Most of them are trying right now to say, I'm not a big tech company, leave me alone. But many of those are crafted in a way that they have negative consequences for. They tried to write for example, the bills about vertical separation. You can't have the platform and sell a product. Some banned some private label products in supermarkets. They banned, if Netflix gets any bigger, it won't be able to make its own shows. I like Netflix shows. So do a lot of Americans, and even some politicians. I think the prospect that some of these go through is far-fetched in terms of the big sort of regulatory structure, new agencies, and this bill, one of them, the Access Act, I think it is, where they create a technical committee inside of the FTC, and anytime any of the platforms want to change their operability interface, they need permission from the agency. I don't think that has any chance of passing. So a bucket where you have some yeses, I think a bucket where the likelihood of success is very low. And I think where the battle remains the most active is this sort of the bucket I'm saving for last here, which has some proposals that touch substantive antitrust law. I think these are actually the most interesting, and the battles are still raging. So maybe the most important one are horizontal merger presumptions. So you've got a version of this in the House. House started with the merger moratorium. Then they came to some presumptions. Some of them are market share based. Some of them, to peel in the House, at least, to peel off Republican voters, are narrowly aimed at tech firms. Some of them are not. There's a merger presumption bill out of the Senate from a Republican. We can talk about the details of these if you want, but the big ticket item on the merger presumption. So for those of you who sort of know or follow American law at all, we have Philadelphia National Bank is a Supreme Court precedent from the 1960s that sort of hung around, fairly inconsistent with what's in our guidelines, but we use it. The agencies use it. They go to court. It says, we get to shift the burden on a showing of post-merger share over 30. Nobody in the agency thinks a post-merger share of 30 means anything, but it's good Supreme Court law, and merger cases don't go to our Supreme Court anymore, so never get overturned other than by congressional action. So we use it in litigation. Plaintiffs use it in litigation. The presumption's gotten a little bit weaker because the post-merger share of 30 doesn't mean much in terms of whether the merger ultimately is anti-competitive. But as a litigation tool for plaintiffs, for the agencies, it's quite useful. And so that they love the thing and would prefer not to let go of it ever. Most of these presumptions codify the presumption that already exists in P&B. So to give an example, the Senate bill says transaction presumptively substantially lessens competition at 33%. And we have Supreme Court precedent that says that already. Fine. There are versions that are stronger, weaker, different flavors of these presumptions. They say irrebuttable presumption at 70 or something like that, right? So that will add to it in some way. I don't know whether any of those bills will pass. I certainly I don't know that they won't. I think those bills, merger presumptions in particular, are where the ongoing fight is going to occur. I think that's where most of the energy is going to happen. Those bills have some support from both Republicans and Democrats. They've got some active detractors from both Republicans and Democrats. They do not, those bills, have the feature of aiming solely at tech firms. And so they make the politics like the older style politics we discussed. They're a little bit less like the sort of new, hey, we can just hit Google bills. They are economy wide. And so the consequences are economy wide. And so the politics look like the old politics, which, suggest a difficult time passing. But I think it is, it's hard to tell. But I think that's where most of those I think are up in the air. I think you'll see lots of talk about the DMA style stuff. You'll see lots of talk about, the Senate has some Section 2 monopolization bills that do presumptions in the unilateral conduct cases. I would put those in the no chance of passing category. So I think you'll see some of those. The Republicans have bills that are in that bucket too. So Senator Lee has a one agency act. It would, eliminate the FTC and do all the FTC at all the antitrust at the DOJ. That's been around for decades. And occasionally when the agencies fight with one another or behave poorly, he gets to bring it out as a disciplinary thing to get the agency's attention, and probably good that he does. But I think that the likelihood of us eliminating one of the agencies is very small. There are a couple of things like that. Josh Hawley has some bills that will never get off the ground that are there mostly for show. So I don't mean by any stretch of the imagination that it's just the Dems with the big transformational bills. It's both parties, but I don't think either of those really go anywhere. I think we almost certainly get a couple procedural budget bills, a merger filing fee bill, some things that will let the agencies litigate a couple more cases because they'll get a substantial increase in their budget and the number of people that work in the agencies. And the middle ground are things like the merger presumptions. Last thing I'll say is I would, if I were a betting man, and I already bet you all a drink on one thing, so I am a betting man. If I were a betting man, I would bet, and this would not, I don't think this would operate through Congress, but sort of on the agency front, 3 things to look for, and I'll just say them and then I'll be quiet and let you ask me whatever you want. The 3 things to look for, I think One, there's going to be some competition rulemaking. Lena has essentially promised it. Rohit wants to do it. Rohit will leave. Commissioner Chopra, I think, will leave to the CFPB soon. But today they have 3 votes, and they all really want to do rulemaking. I wouldn't be surprised if you saw some attempt to do something with this time period where they've got 3 votes. Might just be this week. Might be next week. And eventually they'll get a 5th commissioner after Commissioner Chopra leaves. But I think you'll see competition rulemaking and a little bit of a shift that'll be new in the United States. I mean, competition rulemaking doesn't happen much. And there'll be legal challenges and all of that, but I think that is coming almost for sure. And if I were a betting man, I would say that these agencies are going to throw out our merger guidelines. That's my provocative prediction to end on. I'm not sure if most people here would agree with me or not, but that probably won't stop me. I think they're going to throw out the vertical merger guidelines for sure. And I'd be willing to bet any of you that they ditch the horizontal merger guidelines too and try to rewrite them. Again, good, bad, neutral, your mileage might vary, but that'll be a big deal. I'm sitting here, I'm in South Carolina in the United States teaching a room full of federal judges, antitrust economics. The reason our merger guidelines were effective is because the courts did not have to adopt any of them. They are not rules passed by the agencies. They're a persuasive set of documents, only as effective as their adoption by our federal courts. I think one of the reasons they were effective is because they're a pretty objective, sort of analytical set of documents about how we do stuff and how you should do it. The agencies put in an efficiencies defense in the guidelines, right? Our case law is unclear about efficiencies defenses because most of our case law comes from the 60s, sort of before sort of economic revolution and antitrust. They're a honest set of documents and one that are designed to help judges who are generalist federalist judges who get, 1 antitrust case a year, 2 antitrust cases a year. And I think they are genuinely seen as helpful. And so I think the challenge for the agencies is you throw out a set of documents that has sort of some, bipartisan support and are meant to be objective. They're not revolutionary sets of documents. Nobody reads the merger guidelines and are scandalized by their, aggressive nature or anything like that. You might read them before bed to go to sleep. They're not a super aggressive set of documents. I think attempts to use the guidelines as a weapon to change policy in the courts it's not been tried. So, but I'm willing to bet that, at least from reading what Lena is interested in, I would suspect that is coming. My prediction would be they have a very hard time. The guidelines turn out not to mean anything because the courts don't adopt them. I will stop there. Thanks for hearing me out. I appreciate it. And I'm happy to talk about anything you like. So fire away.
Thank you, Professor Joshua. I mean, was extremely interesting. I mean, I think everybody have a much better view on the details of the developments in U.S. law, and I mean, much better view on these details because we do have an idea as antitrust practitioners here in Brazil on things that happen, and we are following these events. We're following the news on the bills and reports and suits. But this is definitely a much more detailed insight on the inner workings of the U.S. competition law that would definitely helps us to better understand some of the aspects. I think Lauro has a question. Please, Lauro.
Yes. Thank you, Professor. It was great. I have an initial doubt about those bills you mentioned. So, do they treat different industries, meaning the presumptions you mentioned? For instance, there will be some presumptions related to, like, say, big techs or digital markets and other kinds of industries, or this is flat, meaning that let's say the authorities or the administrative authorities will apply their own rules or their own thoughts on that.
There are both types of bills in the portfolio of legislation. Some are presumptions targeted at what they describe as covered platforms, and they've defined covered platforms to basically be for companies. In fact, much of the big political drama moment in the hearing was the definition got changed in the middle of writing the bills because Microsoft was included and the Dems took Microsoft out. And apparently, at least if you believe what you see on TV, the Democrats had given a copy of the bill to Microsoft long before they gave a copy to the Republicans. This did not go well for the Democrats I mean, relative to expectations for the hearing, I think the conventional wisdom was the hearing went worse for the Dems than people anticipated. There was more no votes than people thought on a lot of the bills. Still plenty of yes votes, and that I think is very interesting for all the reasons we described. But to answer your question, both forms of bills, you have some that are targeted at what are described as the sort of covered platforms, really are big tech only, but also plenty that are flat, to use your term, across industry merger presumption. Most of the merger presumption bills are all industry, not aimed at big tech. So there's legislation aimed at making presumptively unlawful nation acquisitions, right? Those are meant to be targeted at the tech firms. They're motivated by the idea that the tech firms buy a lot of small companies, and small and young companies. But the bill itself doesn't have any language. It would affect all industries. So you have some of both is the answer.
Okay, I think I'll start with one of the questions that we've thought. I think one of the issues that you mentioned is this very peculiar aspect of the U.S. law that it's mostly implemented with the negative roles of the courts. I mean, we've seen that there will be changes at the administrative level in nominations, in new people employing new enforcement objectives, enforcement priorities. Do you believe that, and potentially this will be a more stringent approach, do you believe that this more stringent approach by federal agencies will be supported by the courts?
It's a great question, and for what it's worth, you know, I think of judicial review as the role of judicial review in our system as really maybe its most distinctive feature. And I mean, most of the success, and it's an important part of the U.S. antitrust history, is most of the success in changing our antitrust law to the consumer welfare standard, sort of rationalizing the antitrust law from where it was in the 30s and 40s when everything was unlawful and probably criminal. That came from the courts. The agencies had nothing to do with any of that. If you look at our key cases in the 70s and 80s and 90s, where the sort of big revolution in antitrust law happened, you can't find the government as plaintiff in any of them, maybe one. They're not as amicus briefs in those cases, arguing for changes in the law. That was mostly judges. And so antitrust lawyers in the US have grown up around the idea that the judges play an incredibly important role, not just in adjudicating disputes, but in how we should think about antitrust cases. And I think the historical proof is, at least in our system to date, that they've done a better job than the agencies overall in facilitating that change. And so it is right. And I think the question starts with this premise, and I just sort of to co-sign the premise, to think about the judiciary as a very active player in the development of our law. They are not sort of passive transmitters of preferences of Congress. And that can go both ways, right? So my own view is what happens, and I mean, the courts are going to interpret the law. So you have two different ways that the administration can get more aggressive. Three. One is under existing law, they can bring a bunch more cases. I think that's going to happen. I think that's going to happen whether there's any legislative change, whether there's not legislative change. I think that's going to happen if the FTC and DOJ get more budget, or if they don't, they're just going to work longer hours, right? They're going to bring more cases. That's coming. They're going to bring cases into federal court. They're going to bring more administrative cases. The activity level is going to go up. I think the other reason the activity level is going to go up is some of these things like the end of early termination. And, if I were advising a client right now with a deal in front of the FTC and the FTC staff said, we would like to enter a timing agreement with you to give us more time, and we'll deal with you in good faith and we'll get a consent done, I'd say, I love you guys, but I don't think I can enter an agreement with you because it's the commission that signs, not you. And I just can't. And what you're telling the agency when you can't sign a timing agreement with them is sue me or let me go, but decide now. And sometimes they're going to sue you. So I think either which way, both for policy reasons, for institutional reasons, sort of how they're handling some of the deals at the staff level, I think you're going to get a lot more cases going to federal court under the existing law. And the challenge for the administration, especially for an administration who believes the existing laws are too tight or too constraining, they're going to want to affect the way those cases are litigated and what types of theories. I suspect that will largely be a failed venture in the courts. You are not going to win by convincing the court that they should do something other than the sort of consumer welfare economic analysis that's courts have grown up on. By the way, the plaintiff win rate in the US, I'm thinking about mergers right now. The plaintiff win rate in merger cases for the past 30 years is about 88%. They're winning the cases, right? Then maybe they get more adventurous, the win rate comes down, what have you. But it is hard when I look at the win rate in the cases and the types of cases they bring. Our preliminary injunction standard to block a merger is pretty low, right? It's a pretty low standard, and unsurprisingly, the agency wins a lot of those cases. It's hard for me to look at those cases and see a crisis of existing law stopping the agencies from doing anything. Most prosecutors would like a nearly 90% win rate in big transactions. To the extent that Congress changes the law, then I think we're going to get into what really are uncharted waters in judicial review of the antitrust laws. There are some of these pieces of legislation, not so much the presumptions. I think they pass a presumption, and you pass a market share presumption, all litigation becomes about market definition, and we have that. I don't think it'll be a massive change. Obviously, we'll sort of shift from effects to market share presumptions. I think you may see, to the extent that you get a lot more litigation, so more cases going to court, more burden shifting because it gets easier to satisfy the plaintiff's burden by a market share. We don't have a lot of case law developed on efficiencies defenses. I think we've got one. Timo Sprint is what I'm thinking of. We have one federally litigated merger case that sort of spells out an efficiencies defense. One. The deal's settled. The government wins most of these cases, but we don't have a lot of law developed there. I think if I were making adventurous predictions, and why not? I think if we get a sort of bright line market share based system of rules where it's really easy to shift the burden, but we keep the consumer welfare standard, which I think we will. I'd bet money on it. I think you're going to see courts start developing efficiencies doctrine in these cases, because you're not going to be able to reject a case on the front end on market definition because the shares to shift the burden are really low and easy to satisfy. All of that is to say, I think the courts will play an active role in a variety of ways. I think they will continue to. I think attempts to be more aggressive within the confines of existing law, bring more cases within existing law, I think we'll be fine. I don't think you'll see any difference. To the extent that you see being more aggressive means it's not depth, but it's breadth. It's doing sort of things, new things outside of the confines of existing law or guidelines, or you get rid of the guidelines and go to court without them. I think you're going to see the courts push back on a lot of that.
Professor, talking about courts and seeing that you are a betting man, what line do you think the Biden administration would choose for the DOJ nomination, which is, as we know, the key nomination pending for antitrust issues, and, having in mind that we have Lina and Tim, who we all know what they think on the other key positions.
That's a good question. I'm not sure if I'm ready to bet you on this one. So I think if they knew what they wanted to do, they would have already done it. And they would have done it a long time ago. We're sort of getting deep enough into the water or into the calendar year that it's pretty clear that whatever they wanted to do at first, they've decided not to do. And I think that means you sort of start over the search and vetting process, which can take, there's parts of this you can speed up, right? You can get a hearing on the Senate right away. You can force a vote. Having been through this process myself, the part you cannot speed up is the background vetting. The FBI and they kind of fingerprint you and come to your house, and they talk to my junior high school 12-year-old girlfriend to see if I was nice. They do. I was nice. But they go into your background and talk to everybody who's ever met you. It takes time. And so my sense, and this is a little bit of speculation, is that they must have changed their mind early in the administration, or something happened, but that the initial plan was sort of derailed. It means they're sort of searching for a plan B. I mean, for the longest time, they were talking about John Sallet or John Cantor. Would be sort of standard plaintiff side antitrust lawyers would be fine. But for a long time, they were talking about both of them and which one, and big fight between them to lobby to get it, and then nothing, and then nothing, and then nothing. So my sense is they either decided against that, and had to start over a search and are sort of waiting. You don't get into June and July on purpose without a nomination. I don't think that that's happened in a very long time. Sometimes you nominate in February, March, and you're forced to wait until the summer or the fall or what have you to get a hearing, or the other political party stalls because they don't want you to have your guy or your girl. But that's not what we have. They just haven't done it. My sense is that they are deciding now or putting someone through vetting now. In terms of direction, it is a lot harder to put someone. I want to be careful because I mean this at least partially as a compliment. I think it'd be a lot harder to put someone like Lina at the DOJ. A lot of the FTC does a lot of policy. We do rulemaking, we do policy, we interact with all of that. And I think her skill set plays well to part of that job. I think the inside agency, the more the FTC looks like an enforcement agency and goes to court and litigates cases, I think and works with staff to do that, I think the more challenging that job will become. Maybe the most challenging part of that job for Lena is going to be very quickly, she's not going to have a majority. You can have whatever views you want. You need 3 votes. And I think for a lot of the things she wants to do, she's not going to have 3 votes for a while. And that will be the biggest challenge more than anything is you still got to get to 3. On the DOJ side, the DOJ is full at the political levels, is full of really fancy, well-credentialed trial lawyers. Guys who clerked in our Supreme Court and, appellate lawyers and people who came from the White House counsel's office, which are really sort of fancy, hard to get legal jobs in the US. These are people who go and write briefs and litigate cases and think about going to court every day. And the people who decide, Merrick Garland is the Attorney General, was a DC Circuit judge for a very long time, and a guy who knows antitrust, who taught it when he was an academic. The idea that the Attorney General of the United States allows or supports an assistant attorney general who isn't the type of lawyer they want, which largely is going to be somebody who is like them, who runs cases, I think is relatively rare. Not unheard of. Macon Del Rahim, who was the Trump's AAG, is the closest to this, right? He didn't have that sort of background when he was AAG, but if you sort of look back over history, that sort of appointment is relatively rare. Not unheard of, but the AG gets a say, and the president is not going to want to have someone appoint someone and his AG doesn't want. That happens sometimes anyway, right? I mean, president's the president, he gets to decide if there's conflict. And now the White House, I think, is going to be in a hurry. But all of that is to say, I think the way your question is going is, do we get someone like Lena, or do we get sort of someone who is a member of the bar and litigates cases and is more moderate, even if not in political view, and by the fact that they go out and practice every day, which tends to, defend one of these cases. It'll moderate you pretty quickly. And so I think the answer is yes, but almost by definition of the job, I think, you'll get somebody who practices, and then I think somebody who practices antitrust law will almost by definition be a person who is a more moderate and less of a cause lawyer. I don't know who, otherwise I'd bet you, but but I don't know who.
Yeah, very interesting. A question that I have is that U.S. antitrust law is clearly paradigmatic in influencing the antitrust law of other countries. I mean, you see, for instance, in Europe, a more relevant role of efficiency defenses is definitely derived from this movement that you've described in the US of increasing role of economic, orthodox economic thought in the US. This definitely influenced the EU and other countries as well. Do you see that these potential changes in the US law now that we may see either on the enforcement side or even on the legislative side would also affect other countries such as the EU or even other countries such as Brazil?
Yeah, look, I think what's going on right now in the antitrust world is a lot of jurisdictions are impacting each other, and it's a two-way street, not a one-way street. I was never a big fan of the idea, and when I was a commissioner, I was asked to do this. I was asked to, go around the world and wag my finger at other jurisdictions and tell them what and I said no and got in trouble a lot. Because I think the truth of the matter is we we have a lot of experience, and it's good to learn from, but a lot of our experience is making mistakes in front of everybody. And going first means you make a lot of mistakes. And I think there's now there are a lot of costs to having 130 antitrust jurisdictions in the world, but one of the benefits, I think, is you get a lot of experimentation with different approaches, and you get to learn from them, and the learning goes, or should go, but both ways. And I'm a big believer in that. I think the U.S. has a lot to offer, and the U.S. experience has a lot to offer the rest of the world. But I think the converse is also true, especially if a jurisdiction is willing to learn. In terms of what that means going forward for the U.S. and this experience, I think a couple of things are likely, and this was building off something I said a little bit earlier. I don't think the consumer welfare system doesn't go anywhere here. That's not going to change. The primacy of the courts is not going to change. I think we're going to see a period of time where the tech companies are targeted a little bit more. In traditional cases, got brought in front of federal court. I didn't talk about this much because I think the merits of those cases are a little bit separate from the political economy that's going on. But I think the DOJ loses its case against the FTC. Against Google. DOJ against the FTC would be a whole different case. I think the DOJ loses its case against Google. I think Facebook wins its case against the FTC. I don't think either of those claims are particularly strong. Some of the state claims are more interesting. The ad tech claims, I think, are closer. The Texas and Colorado complaint in particular. But the search design stuff, I think under US law, it's low probability of success. The search distribution, the DOJ case, closer. But I would be surprised if I were betting, and this isn't a slam dunk, but if I were betting, I would bet that the DOJ loses that case against Google. I think Facebook loses its case, both the retrospective merger case and the duty to deal case. Really hard to win a duty to deal case here, and get sort of force sharing with a rival. Ask the FTC against Qualcomm. Very, very, very difficult to prevail. I think those cases lose. And I think the big political moment that happens here is what happens when they lose. And I think they're gonna. There's a pending Amazon investigation. There's a case somewhere with Apple. And, I think the plaintiffs will win some of those cases and lose some of those cases. And my view is that's what a healthy system looks like, right? Is you have evidence, and sometimes you win a fight and sometimes you lose. And I think we're going to end up with that sort of distribution of outcomes. But I don't think anything that's happening here is going to alter fundamentally the characteristics of the U.S. antitrust system. My prediction is, and this may be the minority view here, to be clear, I still think it's right, but I think it is the minority view. My view is that what we will end up with, because institutional commitments both to judicial review and to competition are strong. And what a lot of the regulatory structures are asking us to do is to give up one or both of those commitments. I don't think politically that will work here in the long run. So instead, I think you're going to have substitute measures like getting active and bringing more cases. You go to court, you win some, you lose some, you get some relief here, you don't get it there. I think that's what a case-by-case system is supposed to look like. So in terms of its effect on the rest of the world, unclear. I don't think we're going to end up looking a lot different institutionally 4 years from now than we do now. I think we'll have a lot more cases. I think we'll bring a lot more cases without guidelines. I'm not a big fan of that. And, it will be a different era in terms of activity level, and lawyers will be busier, not negotiating consents with agencies but going to court. I think a lot of antitrust lawyers in the United States sort of build careers about staying out of court. That's the way antitrust lawyers are raised, right? You go and you get the consent and you stay out of court. I think that's changing. So there are definitely some things changing. I don't want to be taking the position that all of this is nothing. It's not nothing. It's an incredibly important moment, and I think there are really important changes. But I think the changes are going to be in activity levels and the amount we go to court, and the types of claims that are being brought. But the change is going to happen not so much through Congress, but through the outcomes of those cases. I have no idea if I answered your question, but I tried.
No, definitely. That's interesting. In my personal view is that, especially if there would be some different guidelines, a new merger guidelines, for instance, with some presumptions on these or that sector or these or this situation, this could potentially easily influence other jurisdictions, because it's an agency-backed document that could be seen by other agencies as a relevant document to be at least to be read and to be considered in potential policy changes in their own jurisdictions. Lauro?
Yes, Professor. Do you know if this not going a little bit further than antitrust, but do you believe this changes or these bills or will mean something related to a greater protection of national interests or American interests due to this fight against China, against Russia? Do you mean that these two things, I mean, this new, let's say, line of antitrust and these new bills, they tend to reinforce the national interest somehow?
It's a great question as well. I think you're seeing more of that sort of rhetoric and concern in some of the bills, for sure. I think that's an absolutely correct observation. I think interestingly, I think some of the Republican pushback against some of these bills is also using sort of national interest protectionist rhetoric. So the Republicans in Congress sort of are fond of saying things like, we're letting all these other jurisdictions beat up our tech companies. Only we can beat up our tech companies. If anybody's going to get $1 billion from our tech companies, it's going to be us. But also sometimes takes the form of China is coming and they're not doing this to their tech companies. So we shouldn't be doing this to ours. So no doubt that rhetoric is more pervasive than it used to be in the United States. Also no doubt the United States has engaged from time to time in its own protectionist sort of competition policy decision making. I don't know if less or more than other jurisdictions, maybe less on average over time. But I think most of that protectionist talk is limited to Congress, right? And so I suppose because of my view that most of what Congress is talking about will not become law, I don't think you see national interest and protectionist talk. You don't see it inside the agencies. You certainly don't see it from the courts. Mm-hmm. And so I think it has been limited and will continue to be limited. The biggest example of that I can think of in courts is the DOJ's intervention in the FTC's Qualcomm case. So the DOJ filed, this was a very odd situation for us. You had the FTC as the plaintiff, and you had the DOJ filing not on behalf of or in support of the defense. in an antitrust case, the case was brought before the change in administration. You had a change in administration, but the FTC was tied 2-2. So the FTC couldn't settle the case if they wanted to. They didn't have the votes because they had 2-2. And so no one in the administration, no one in the FTC could speak for the administration. So the DOJ came over and said, on behalf of the Trump administration, here's what we think. Pragmatically, I think it's fine if the administration wants to opine on a case, they should, and they couldn't through the FTC. But in the antitrust world, the idea that they came over and the DOJ intervened in the FTC's case on the other side certainly didn't help relationships between the agencies. But the grounds on which they came in were in part national security, right? It was in the Qualcomm case. It was very much if we go after Qualcomm in this way, we are subsidizing a Chinese competitor, and that will put us in national security risk. Court doesn't rely on it. The Ninth Circuit doesn't rely on it. It does sort of a fairly standard antitrust analysis in rejecting the FTC's case. But that was really the first time I had seen in what amounts to a substantive antitrust brief, this type of argument come into court. I'm glad in a way it was not effective and the court didn't rely on it. I don't want to learn how to be a national security lawyer. Too late for me to learn new stuff. But my view is that rhetoric is getting hotter politically here. Mm-hmm. But at least for now has not made it inside of the agencies or courts, and I really don't expect it to.
Thank you.
Thank you. Professor Joshua, I think we are heading to the end of our arranged time for the event. I would like to really thank you for your availability and for this fantastic presentation of such important developments in the U.S. law in the name of Ibrac, because I think we leave these events much more well informed on these developments, on how they can affect our daily lives as Brazilian practitioners here of antitrust law. And saying that, I would like really to thank you for your availability and your presentation about these issues.
It's my pleasure. Thank you all for having me, and I look forward to when we can do this sort of things in person.
Definitely.
Yeah.
Thank you, Professor.
Thank you, everybody.
Thank you.
Thank you. Bye-bye.
Bye-bye. Thank you very much.
Thank you.